Most people think a bank account is simpler than it really is. They think the arrangement works like this. I earn money, I deposit money, the bank holds it for me. If I need it, I take it back. Clean, moral, intuitive. The account feels like a storage box with a logo on it, a digital vault with a debit card attached, a polite service relationship where the institution is basically being paid to keep your cash safe and accessible. That is the mental picture most depositors carry, and in ordinary times the bank is perfectly happy to let you keep carrying it. Your balance shows up on the screen, your card works, your transfer goes through. Nothing in daily life pushes back hard enough to force you to ask a more adult question. What exactly did I agree to? I have spent most of my life reading contracts, annual reports, footnotes, regulatory language, and all the dull material that other people skip, because it looks boring right before it becomes expensive. That habit has made me a lot of money and saved me from some very avoidable mistakes. And if there is one thing I have learned from documents, it is this. The part that matters most is usually not the part people are encouraged to read. It is the part buried in the middle after the friendly explanation and before the place where most eyes give up. That is exactly how bank account agreements are written. People think what they signed was a service contract. Much of what they signed is a permission structure. That is a very different thing. A service contract says, in effect, here is what we do for you. A permission structure says, more quietly, here is what we are allowed to do when our interests and your assumptions stop matching. That distinction matters enormously once you begin holding real cash in a bank account. Now, before I go any further, let me say something directly. This is not paranoia. It is not a conspiracy story. It is not an argument that your bank is about to confiscate your life savings tomorrow morning. It is a much more useful point than that. It is an argument that most depositors misunderstand the legal nature of the relationship they already entered. They think the account belongs entirely to the realm of convenience and customer service. In reality, it also belongs to the realm of institutional rights, regulatory allowances, internal profitability models, and contractual language that becomes very consequential at precisely the moment you are least emotionally prepared to discover it. That is why I care. Not because I expect drama every day, because the hidden clause is always most important on the day you wish it did not exist. Now let us begin with something that sounds almost trivial and turns out not to be. The number $20,000. Most people assume that if a financial story focuses on a round number, it must be because the number appears directly in some famous statute or regulation. Sometimes that is true. In this case, it mostly is not. $20,000 is not some magical federal line at which alarms go off in Washington and your account changes color. It matters for a more practical reason. It is roughly the level at which an ordinary retail depositor begins to become economically legible to the bank in a different way. A customer with a few $1,000s in checking is one thing. A customer with $20,000 or more sitting in savings or checking and no corresponding debt relationship is something else. From the bank's point of view, that person is not automatically the sort of good customer the public imagines. He is not paying them mortgage interest. He is not carrying a profitable credit card balance. He may not have a car loan, a line of credit, or other products attached. He is simply holding deposit balances the bank must service, report, administer, and in many cases pay interest on. In other words, he is a deposit only customer. That phrase matters because it tells you something uncomfortable. The institution does not necessarily view your account the way you view your account. The bank sees a balance sheet relationship that either earns its keep or does not. The larger the deposit, the more seriously the bank thinks about what rights it has, what it can do with the relationship, and how that cash fits into its internal economics. This is why I always tell people to stop imagining institutions as moral companions. Institutions are systems of incentives wearing customer-friendly language that does not make them evil. It makes them systems. Now, the first right that matters here is something many people have never heard of, even though they have already granted it. The right of offset, in plain English. If you owe money to the same bank where you keep your deposit account, the bank may have the contractual right to take money directly from your deposit account to satisfy that obligation. Not after a long court battle, not after a dramatic confrontation, not because you signed something separately that day, because you already agreed to it when you opened the account or the credit product, and the bank's legal documents were written to let the institution move first and explain second. That is what shocks people. They imagine current debt and deposit balances as separate boxes. The bank may not. Now let me be even more precise. Many depositors imagine this. Right only becomes relevant after obvious delinquency. They picture themselves missing payments for months, ignoring notices, letting the relationship decay until the bank finally acts. But agreements are often written more broadly than that. The right is not always confined to balances long overdue. The phrasing frequently gives the institution room to apply deposit funds to obligations it determines are owed to it, subject to the terms it disclosed and the law that governs the relationship. That means the comforting retail story. "I'm current, so I'm fine," is not as strong as people think. Again, this is not about inducing panic. It is about correcting a mental model. Your savings at the same institution where you owe debt are not necessarily a wall against that debt. They may be the first thing standing closest to it. That is why I have long preferred clarity over convenience. If one institution both holds my cash and profits from my liabilities, I want to understand exactly which side of that relationship gets treated as first priority under the documents, not under the marketing material. The second clause that matters is the one governing access timing. This one is subtle, which is why it catches people flat-footed. A balance can be visible and still not be usable. That is one of those realities that sounds too obvious to mention until you realize how few people behave as though they really understand it. They see an incoming deposit, a large check, a transfer, a balance jump, and they instinctively translate visibility into availability. The money appears to be there, therefore the money must be functionally theirs for immediate purposes, not necessarily. Banks are allowed, under disclosed circumstances, to place holds on incoming funds beyond the naive timeline. People imagine federal rules create minimum structures. Yes, but institutions write account terms that define the situations where they reserve more time. Large incoming deposits, certain patterns, certain account conditions, certain risk judgments, the language exists. Most customers only discover that it matters when the funds they can clearly see on the screen cannot yet be withdrawn or moved the way they expected. This is a deeply modern kind of frustration. The money is there until it isn't. The balance is visible, the access is delayed, and the delay begins not when you discover it, but when the bank counts it. That distinction matters in the real world, because large balances are often most important at moments of urgency. A person is not usually moving a significant sum because he is bored. He is closing on something, covering something, protecting something, or solving something. Delay in those moments is not theoretical. It can be costly. That is why I keep saying visibility is not the same as control. Now we arrive at the third power, and this is the one that reveals how much people confuse banking relationships with friendships, the right to close the account. Most depositors know, in some abstract sense, that the bank can choose not to keep a customer forever. They think of this as a remote institutional option, something reserved for fraud, egregious misuse, or weird edge cases that happen to other people. But the contract language is typically much broader and much colder than the public assumes. The institution often reserves the right to close or restrict the relationship with or without advance notice, according to terms that preserve its discretion far more than your comfort. That is important enough. What matters even more is how the money comes back. People imagine that if the bank ends the relationship, the funds will simply move in some convenient modern way to wherever they need them next. But the return mechanism often tells a different story. The money may be returned by mail, then that instrument must be deposited elsewhere. Then it becomes subject to that receiving institution's own hold and availability policies. Look at what just happened. The money is legally yours. It was visible yesterday. And yet, through a chain of ordinary contractual mechanics, it can become practically inaccessible for days, at exactly the moment you were not planning for delay. This is why I dislike any financial structure that concentrates too much faith in one institution's goodwill. I do not mean that every bank wants to inconvenience you. I mean that convenience is not the bedrock of the relationship. The contract is. The fourth clause is the most conceptually important because it changes the way you think about what your deposit balance even is inside the system. Deposit reclassification. Most ordinary depositors have never heard the phrase, and that is not because it is irrelevant. It is because the mechanism operates at a layer of banking life most customers are never invited to examine. The customer sees a balance and thinks in personal terms. My money is sitting in my account. The institution sees categories, reserve requirements, internal classifications, regulatory treatment, liquidity management, and accounting room. That does not mean the bank is secretly stealing the number from your screen. It means the legal and operational structure of your deposit exists in a more dynamic internal universe than the customer-facing interface ever reveals. That is why I say again that the account is not merely a storage box. It is part of a regulated institutional machine. Your balance may look static while its internal treatment shifts for purposes you will never see in the app. That is not because someone forgot to tell you. It is because nothing in the customer experience was built to make you ask. Now, I want to be very careful here. People who hear language like this sometimes leap to melodrama. They begin talking as though ordinary banking itself is an imminent collapse story. That is lazy thinking. Most of the time, these mechanisms remain invisible precisely because nothing stressful is happening. The machine runs, the clauses sit there, the relationship appears normal. That is the point. Contractual power is most effectively exercised when it does not need to introduce itself daily. But if you are a thoughtful person, and especially if you are holding meaningful cash at one institution, the right response is not panic. It is structure. You should know what the account agreement says. You should know what products you owe money on at the same institution. You should know how much of your liquidity depends on one institution behaving as you hope, instead of as it is allowed. You should know how long access delays could become under the terms you already accepted, and you should stop treating the bank as though it were merely babysitting your money. That is the childish version. The adult version is more exact. The bank has a contract with you. That contract contains powers. Those powers were disclosed. They are dormant until they are not. This is why I think the most dangerous financial assumption a person can carry is not that the market may fall or that inflation may rise. Those dangers are at least discussed openly. The more dangerous assumption is that a deposit account is simply a neutral service arrangement with no deeper institutional asymmetry built into it. That assumption leaves people unprepared. It leaves them reading the agreement only after the moment they wish they had understood it before. And that, in finance, is usually the most expensive time to learn anything. Now, let me tell you how I think about it in practice. Cash is necessary. Liquidity is necessary. Banking relationships are necessary. But concentration of trust is not necessary. I want enough liquidity to function, enough operational cash where it is useful, and enough structural understanding that no single institution's exercise of its documented rights can surprise me into weakness. That does not require theatrics. It requires distribution, awareness, and realism. Do not keep debt and large idle cash balances under one roof casually. Do not assume a visible balance equals immediate control. Do not assume the account will remain available simply because it always has. Do not assume your mental model of fairness governs the institution more than the language you signed. Those are the mistakes. Now, I am not here to tell every person one magical number for how much cash should sit at one bank. That would be dishonest. The answer depends on life stage, obligations, account purpose, debt relationships, and what other structures you have in place. But I can tell you the question is far more serious than most people realize. Once your balances become meaningful, the convenience of leaving everything under one roof begins colliding with the rights you granted. The institution inside the agreement that is not a reason to fear the system. It is a reason to stop being naive about it. And if I could leave you with one final thought, it would be this. The clause that matters most is never waiting for a crisis to become real. It became real the day you signed it. The only uncertainty is whether you will understand it before or after the bank decides to use it.